Good morning. Okay, we've got a full rules calendar today. We are honored to have our chairman of Appropriations Committee to bring us some good news about the budget, I think. Chairman England.
Good morning, Mr. Chairman. Welcome to the Appropriations Room. I couldn't help it. Ladies and gentlemen, bring to you the FY20 budget, House Bill 31, and full committee just passed it out, and we're on schedule to have it on the floor tomorrow. Be glad to answer any questions as the chairman gets up and leaves. Didn't mean to hurt your feelings.
I hope that's not an indication of anything.
Well, me too.
Okay, Chairman England has presented House Bill 31. Do we have any questions from anyone in the committee? Okay, I don't see any questions. I guess we're ready for a motion. So move, do pass. Here, second. All in favor say aye. All opposed, like sign. Very good. Thank you, sir.
Thank you.
Hey, you beat your record. You said 2, and it was only about a minute and a half. Oh, Chairman Dollar.
Thank you, Chairman, and I just want everybody to know Chairman Smith always tells everybody to go by rules.
Yes, sir, I do.
Yes, sir. Second page, House Bill 341, again bringing you this is an update to Georgia's piracy law, bringing us in line with federal code.
Okay. Any questions from anyone on the floor? Oh, seeing none. Thank you, sir. Representative Petrie.
Thank you, Chairman. Good morning, members. I bring to you today House Bill 202 under modified structured rule. About 3/4 way down the page. I have before you as well, if you will look, I put on some of your desk a copy of what we're trying to do. It is a list of ICE detainers currently in the Georgia correctional system. So what this bill does very simply, our Department of Corrections has a great database on all of the individuals who are inmates in our state system. And by the way, this does not relate to jails in any way, but only to state correctional facilities. And they do a great job of creating reports there. What they aren't doing is aggregating this data. So this, in the interest of transparency and public safety for the public, if they're interested in the degree to which some of these things impact our society, this would aggregate an ICE detainer list and show the offenses. It has no specific individual data, but it has data on the number of offenses and the number of ICE detainers currently in our state correctional facilities. And you will see there are 1,505 individuals currently in the Georgia correctional system today, almost all of those for violent and sexual offenses. That's very simply what I'm trying to do, Mr. Chairman, and I'll stand for any questions.
Okay. Leader Trammell. Oh, try Martin's, 2 over. Since he can't talk anymore in this room, according to the rules, Chairman, from yesterday.
Thank you, Mr. Chairman. To the presenter, isn't it true that there's a concern that the language in the bill is overly broad and vague so that it would include any non-citizen in your bill?
I mean, there are folks that are concerned with the bill in any number of ways. Mr. Minority Leader, I think that what I did was actually offer to change the language to speak specifically to ICE detainers, because that list you have before you is what I'm trying to accomplish. I have met with Legislative Counsel who have made it clear that this language accomplishes what I want. So that's the only answer I can give you.
Okay, no other questions. Thank you.
Thank you, Chairman.
Representative LaHood.
Thank you, Chairman Smith and members of the committee. I'm here to present committee substitute to House Bill 374, which the intent is to define criteria and conditions in which a certified medication aide who is employed by an assisted living community can administer liquid morphine to a hospice patient. This is a practice that has been happening for years until about a year and a half ago. The Department of Community Health determined that a certified medication aide should not be administering this medication. So what I've done, along with others, is brought all the stakeholders to the table, including the Department of Community Health. They helped to write this bill. They gave a lot of input into it. They spoke in favor of it at the committee hearing a couple of days ago. It was a unanimous vote to get it out of committee, and it provides a lot of safeguards, pretty narrow window of opportunity for certified medication aides to administer this liquid morphine to hospice patients who were most of the time on their deathbed and need this pain relief, and this will only be permitted when hospice is not available. And it's the same thing a family caregiver could be trained to do if the hospice patient was in their own home. I'll take any questions if there are any.
Okay. Against my better judgment, Representative Martin.
Thank you, Mr. Chairman, and then to the gentleman, if you go for a question, I want to talk with you further offline on this, but I want to pose this question because it's happened in a situation that I'm very familiar with. There are places where, isn't it true that there are places where hospice is called in and it's not an imminent death situation, it's a patient comfort situation?
There are some cases like that.
A pain management situation. And it's true. My concern here is to be very careful about someone not trained over medicating that. I am familiar with at least 2 situations where pain management situations were medicated as if they were end of life situations, and quite frankly almost killed patients. And so I want to talk to you further just to make sure that in those 2 split situations that we don't send somebody home before they're ready, if you will.
I appreciate that concern and you raising that, and I'll just reiterate that the criteria for this is pretty narrow. Hospice will be providing training to the certified medication aide who is already certified by a state certificate to administer all sorts of medications. The department just decided about a year and a half ago to exclude this one. But again, the department has been at the table in these conversations, and they agree with what we're trying to do here, and they voiced their support in the committee meeting. I do understand your concern. This is no different than what a family caregiver with no medical background at all can be trained to do inside the home. I'll be glad to talk with you offline.
Let's do that.
You have no more questions.
Thanks.
Representative Smith, is this your first bill?
Yeah. Let me think. I believe it is, Mr. Chairman. Anyway, no comment. Thank you, members of the committee, Mr. Chairman. I'm bringing to you today House Bill 302. It's on the back side under modified structure. House Bill 302 is what I consider a property rights bill and also a workforce development bill. It focuses on local communities and local government putting more restrictions above and beyond the zoning ordinances and the building codes when you go out to build a house for somebody on private property, and it gets into the aesthetics of that, what the houses should look like, what color. But it's a pretty short bill, about 2.5 pages, and it focuses strictly on restrictions on aesthetics on homes. And I certainly would appreciate any questions or any comments, and just trying to look after the citizens of the state of Georgia.
Mr. Whip.
Thank you, Mr. Chairman. Representative Smith, for those of us who couldn't be in the committee and may not have had the opportunity to hear what caused this bill, would you mind speaking to some of the conduct and situations that you've seen may have, some of those overreaches that you would reference?
Yes, sir. There are certain areas of the state where whole counties, and in certain counties you can't use any vinyl siding on your house. There are certain areas of the state where if you have a lot that has 5% or less grade, is okay for a slab, but if you have to grade the lot, you're not allowed to put a slab on there. Some areas of the state give you a choice of what color the exterior of your home can be. I think I'd have to let them talk to my wife if they're going to tell her what color the house is going to be, you know. It also, in some areas, they actually tweak the floor plans where your rooms are arranged. What type of siding, as I mentioned with vinyl. The interesting part about this is strictly the 8 items listed on the first page of the bill. It doesn't touch zoning, it doesn't touch codes, it doesn't touch historical, Georgia or federal, or local, state, or federal landmarks. It doesn't touch HOAs. So it's strictly, where do we draw that line in the sand where we're trying to let private property owners build a home that they want instead of the government trying to tell them what their house should look like? And to me, that crosses that line, in my opinion.
Do you think that in some of the areas where these are impacted, home prices are being driven up as a result of these regulations?
Well, I can't tell you a dollar amount, but if you look at it, and everybody in here is pretty much a business person, if you look at it and you're limited to what you can put on as siding and what color your house has got to be and what the way your roof is structured, I would almost have to believe that it could add an increase to cost because you're limited as what you can choose from. So it's kind of a choice issue. I guess the interesting thing to me is people buy these lots and they abide by all the rules and regulations on the books, and they pay their tax on that property, but yet as they start to build their home, they're still being told what their home should look like. Looks like to me a private property owner should be able to decide what their house should look like, and personally.
Thank you.
But not to belabor the point, do you not agree that the private property owner who lives next door to that house has some rights too?
They do on their property.
So you can trash everything that you want to do next door to me and I've got no say-so over it?
There are ordinances in cities that are established as far as cleanliness.
No, I'm talking about appearance.
Appearance? Well, I guess the appearance, I travel about 50,000 miles a year in this state in South Carolina doing business development, and I'll give you an example. I hadn't seen a purple house yet, but I hadn't seen an orange house yet, and I see a lot of homes. I get off the interstate, but I go back to private property rights. Who's paying the tax on that property? And that's an individual choice. So,
Representative Fleming.
Thank you, Mr. Chairman. Welcome to the Retread Caucus.
Thank you, Mr. Chairman.
From one retread to another. I was trying to listen closely to what you were talking about, Representative Smith, and I thought I heard you say this has nothing to do with zoning. But right. Then Section 2 of your bill specifically talks to zoning. Mm-hmm. It actually affects our code section that deals with the definition of zoning.
Okay.
What is the purpose of Section 2?
I think it makes actually clearer. It would improve the definition of zoning. I've not had any. Yeah, go ahead.
How so?
Makes it clearer, just clearer language. It lists them on page 3 under the zoning lines 70 through 80, all the things in the zoning ordinances that it does not do. It doesn't interfere with any of those. So to me, it's just a clearer definition of, hey, it listed code sections and it listed all of them that we're not interfering with. It listed zoning and it listed all of them that this is purely an aesthetics section.
The reason I asked that question, and maybe you can get this answer and we can talk about it later, but as I understand our Georgia Constitution, the power to zone is given through the Constitution to cities and counties.
Correct.
And we are allowed as a legislature to affect the procedural rules that deal with zoning, when you hold hearings, how you have to run ads, so forth and so on. But we're not necessarily allowed under case law and the interpretation of our Constitution to affect the substantive rules. And by listing places where you can zone, and that's what I read line 70 through 80 to be, you, by implication, are saying other places not listed you can't zone, you cannot zone. And as I was looking down this list, I was thinking that, for example, my hometown, I believe, and others I'm familiar with, there's a requirement that all gas tanks, for example, be zoned in an area where they're underground. You can't have a filling station with a gas tank above ground for many reasons. As I looked through that, I was wondering if that was in there.
Well, that's a specific area that I'd certainly go look at. I can't give you an answer on that. It wouldn't be a correct one, so I wouldn't want to speak on
One other
that.
question, if I may, Mr. Chairman. On line 39 of the bill, which is on page 2, it says no county or municipal corporation shall adopt or enforce any ordinance or regulation relating to regulating building design elements as applied to one or two family dwellings. My assumption is two family dwellings is a reference to duplexes there.
All right, one more time now, just a little bit.
Yeah, I apologize. On line 39, it makes a reference to something called a two-family dwelling.
Right.
And I would just read that as a duplex, basically,
Right.
in common,
That's what I read it as.
common terms. What can we and can we not do to duplexes because of its inclusion there?
Again, it goes back to the aesthetics, the things that are listed on that first page, A through H.
And what I'm thinking of is that I am familiar with local ordinances that say that this has to be a single family dwelling area, that you can't have duplexes and in some cases apartments in certain areas, and I was trying to figure out how it may at all affect that.
Well, I think that, again, I guess I would go back to that back page on 70 through 80 and look at land use. That could possibly fall under that category. And two, Mr. Chairman, now, I'm not a lawyer, so I don't want to pretend like I know the law, but I'd say that could possibly go under the land use, or maybe there's another category that fits it better, but that's the one I would go to.
Thank you. You did pretty good for a retread.
Thank you, sir, Mr. Chairman.
Chairman Powell.
Thank you, Mr. Chairman. As I read the bill and as I hear you and what you've understood, and I've heard the talk about zoning, this has nothing to do with zoning. Now, I came from the ranks of a local official as a county official, and it doesn't have anything, if I understand right, this doesn't have anything to do with the local governments telling someone what you can do in the way of zoning, and zoning is usually the purpose of the property. This only tells them that the aesthetics, this growing disease that we see of this creeping kudzu of local control, when one county or one city does it, the next one seems to think that's great. But we're not talking about zoning. We're only talking about aesthetics. We're not trampling into their rights on historic districts or areas of restricted covenants. This is only about the material usage, and it doesn't even bother the code sections. It just says a city can't tell, or a city or a county can't mandate, well, you can't use this material or that. We're talking about hardy board. You know, we've seen a lot of the cities that's prohibited vinyl siding. I understand some of them are saying you can't use hardy plank and you can't use this material, that. But in reality, for affordable housing today, some people can't afford to brick a home. Some people can't afford to put cedar on a home.
Right.
And is that not what this bill does? It just basically says that they can't, in non-restricted areas, that they can't mandate the aesthetics.
Exactly. It's purely aesthetics, nothing structural that would be affected. You're correct, the zoning and all is still in place, but it's just that outward look and maybe the arrangement of floor plans in the house. You know, in the workforce, we have people that need to build a home maybe on a slab to save a few $1,000s and put that money somewhere else. So I just hate to see us cross that imaginary line where it gets into private property rights. And there again, that's my opinion, to allow people to build the house they want after they've paid all the tax and all on the property and abided by all the rules. I just like to see them be able to build what they want.
Also, is it not true that somebody in the city government or county government may have watched the Truman Show too much?
Oh, I don't know about that. I will say that I was a member of ACCG at one time. I was a Harris County Commissioner back in the 80s, and actually was chairman 2 years, fortunately. So I understand a little bit about local government also. But I do appreciate the opportunity, Mr. Chairman.
Chairman Martin.
To the gentleman, a couple of questions. I have a little experience sitting in front of folks in zonings, and you keep saying this is not zoning, right? This doesn't affect zoning, and that's your statement. Isn't it true that most all the zoning ordinances in counties and cities in Georgia, the design standards are included in the zoning code?
If that's what you say.
Therefore, it directly impacts zoning? Because
the aesthetics part.
The design standards are in the zoning? Isn't it further true that, I believe as Chairman Fleming pointed out, that zoning is allowed by the cities and there are things that go along with it, and every zoning ordinance has a process for a variance? Isn't that true?
I would hope.
Okay, isn't it true that if there's a process for a variance, if one of these one-offs that you mentioned come up and somebody feels like they have a situation, they can take it before their city council?
If they so desire.
Isn't that true? Isn't it further true that you say somebody that pays their taxes and obeys by all the laws, but they don't want to abide by this one, this is a law on the books if it's a city ordinance, is it not? City ordinances are laws, are they not?
If you so state.
So we think we're going to sit here today and decide that we know what's best for the city that I live in, and yet the 50,000 people, put their mayor and city council. And is it not true that all those zoning ordinances are advertised locally and people can speak on them and speak for them or against them, and they take that into consideration and they do what the local community wants in their area? And it's duly passed in a first and a second reading before people that are close to the process, not and sometimes hundreds of miles away in this building.
In your area, if you so state.
Is it not true, Mr. Smith, Representative Smith, that this is a perfect example, Chairman Powell, of what I think. In this building, we do 2 people when we ought to be doing 4 people.
And that's exactly what I'm looking at, private property rights for people. Had a lot of counties call me up, and they're for the bill. So.
Mr. Chairman, one further question, since you want to bring that up. I just would ask you, if this is such an issue, are you aware of any cases where somebody has sued a city for a taking of their property based on one of these?
I don't have any knowledge of that.
Is that not available to them under the Constitution if they feel like this rises to the level that it's a taking of their personal property?
I could go check that out.
Isn't it further true that if we're going to get there, and I'm not a lawyer and didn't stay at the Holiday Inn last night, but if we're going, dang, I went right there again, didn't I, Mr. Chairman? No, it's a serious question that how do we decide one, a dwelling with one family living in it or 2 families living in it, how is that not a violation of an equal protection? Why not 3? I mean, how is 3 families living in it, they can regulate it, but 2 they can, or 1 they can't? Well, it's pretty clear.
All right, we got a couple of more folks that want to ask questions, so let's move on. Chairman Ballinger.
Thank you, Mr. Chairman. Representative Smith, on line 39, you specify building design element. And on line 16, it says type of exterior cladding material, and you had referenced specifically vinyl siding. And on line 19, you specified location of architectural styling of windows and doors. In my city and my county, if there are certain densities that are allowed, fire retardant materials are required. How would that impact that? Would that prohibit the safety requirements?
Well, as I understand it, all the materials that can be used on homes that are built in the state of Georgia are approved before they can be used. And those materials go through a testing program before they're put on the approved list.
But if there's a higher density, or if the buildings are so far apart, then they require a higher fire protection rating. And according to the way I'm reading your bill, that would be prohibited if this were to pass.
Well, again, I go back to the materials and the testing by the state. You know, I would think that the state of Georgia is taking into consideration all of Georgia, rural Georgia, metro Georgia, spacing of the houses. I would think that would be part of their criteria when they test the materials.
But whenever they're requiring that rating, that would be prohibited by your bill, the way I'm reading it.
There again, I go back to the materials that were tested. I guess we just have a difference of opinion right there on what the wording, what it sounds like. So, but no, I understand safety, but the aesthetics, in my opinion, do not interfere with safety or structural of the homes.
Mr. Chairman, if I may, just one more question. So in other words, if vinyl siding is prohibited, but my city wants to forbid vinyl siding because it doesn't reach the fire retardant standards that they feel like are necessary, your bill would prohibit that, correct?
If those materials are on the list and they're approved and withstand and come up to the gold of the fire retardant, I guess we got to give a little bit of, I won't even say that. Okay. I think they would still be on the list, and yes, they could use that material if it met the code.
Representative Hawkins.
Representative Smith, is it true that Carl Rogers asked you to carry this bill and got you into all this trouble?
No, I'll have to say that's not true. No, not my buddy Carl. Huh? Okay.
Mr. Williams.
Oh, okay.
Thank you. I guess I could ask about bicycles or ask Representative Martin offline if his opinion about ordinances applies to sanctuary cities and minimum wage ordinances as well. But to the author of the bill, is there anything in the bill that would preclude a city when a property owner petitions for a zoning change? Let's say they want to go from one broader zoning, say R1A in our case, and wants to get a higher density, but they petition the city council for a favorable zoning change that would allow, in this case, more density in a housing development. And the city council, as a condition of granting him this otherwise not zoned situation, that he or she agrees to minimum standards of like where you place the garages, rear alleys for garbage pickup, the high density housing that's so prevalent or popular in some of the suburban areas. Is there anything in this bill that would preclude a city from voluntarily, not taking away any private property rights in this case, but granting that those conditions to be met? Do you have a problem with that, or would the bill stop that?
No, sir, I don't. I think that's a mutual ground or a balance that's made between a property owner, a builder, the city, the officials. That's a great way to do it. I mean, that's a proper way to handle a situation when you have an opinion of how you'd like these lots developed compared to some others, and I think that's great. That's a great approach.
Chairman Benton.
They've asked my question. Thank you, sir.
Okay. Chairman Tankersley.
Thank you, Mr. Chairman. My concern is that part of my district lies in a high wind zone, and nearby areas have been, suffered great damage from hurricanes. So this particular portion of my district has prohibited vinyl siding because it's quickly just ripped away. And I have great concerns about this bill because I don't believe that one size fits all. And this is certainly an example of that. And it's problematic in towns, I think, with universities like I have in my district, and the number of people that want to sometimes, I guess this could allow them to have as many as 8 people in a single family residence. And that is becoming a problem in other areas. And so I just wanted to express that concern with this bill.
No, and Representative Tanksley, I appreciate it, and you and I have talked several times, and always open to talk to anybody about it, and I certainly appreciate your comments.
Thank you.
That's all, Mr. Whip.
Thank you, Mr. Chairman. Since we've now thoroughly examined the Retread Smith's bill. I think it's also appropriate for us to wish him a happy birthday today.
Man, come on now.
And with that happy note, you can go.
Thank you, Mr. Chairman. I appreciate it. Y'all have a great day. Thank you. I appreciate your favorable vote.
Representative Rich.
Good morning, Mr. Chairman, members of the committee. I bring to you today House Bill 134, which is located about halfway down under Modified Structure Rule. Georgia law currently provides for the creation of county law libraries and the creation of boards of trustees for each of these county law libraries. They are funded by surcharges on actions that are filed in courts of record. A couple of sessions or years ago, this legislature enacted legislation to perform audits on these accounts that are managed by the Board of Trustees. I come to you today with a revision to the provision that has, to the code section that has a population cap. According to the statute as it currently stands, counties with a population of 950,000 or more will no longer have these funds, these surcharges diverted to the Board of Trustees account for maintenance of the law library. Instead, they will go to the general county fund to be used as they see fit on court expenditures. So the courts in Cobb, Fulton, and Gwinnett have asked us to remove this population cap such that they can continue to operate their county law libraries as they have been doing. These are needed and much used by pro se litigants who come to the courthouse and are in need of conducting their own legal research. So I ask for favorable consideration of this bill, please.
You have no questions.
Thank you. This was a lot easier than the last time.
Representative Danilowitz.
Thank you. I bring before you today House Bill 281. This is a straightforward bill. It addresses Code Section 16611, 16669. It is second from the top on the second page under Modified Structured Rule. This bill is very simple. It makes pimping and pandering, which are those aforementioned code sections, an aggravated misdemeanor on the first offense. Second and subsequent offenses are a felony.
You have no questions, not even from Chairman Martin. No, we aren't recognizing him.
Thank you.
Thank you.
I appreciate your consideration.
All right, members. Chairman Efstration.
Thank you, Mr. Chairman. I bring to you House Bill 234. It's toward the bottom under Modified Structure Rule 234. This is the Anti-Human Trafficking Protective Response Act.
You have no questions. Chairman Dempsey.
Yes, House Bill 197, the Georgia Data Analytics Center bill, which will allow us to work much more effectively as legislators and be much more fiscally responsible.
You have no questions. Chairman Stevens.
Thank you, Chairman. On the front page, House Bill 244, as we continue our conversation on pole attachments for the EMCs, and also on the back page, Good Friday bill, H.R. 239, the Savannah Logistics Technology Corridor. Good Friday bill.
You have no questions. All right, Representative Bodie, and if you'll use Chairman Martin's microphone.
Yes, thank you, Mayor. I bring again today House Bill 258 at the bottom of page 1 under Modified Structure Rule. Again, it just adds the offense of aggravated sexual battery to the current tolling statute for victims under the age of 16.
Any other members? Okay. Rather than come back we've only got 5 bills on the calendar for today. So rather than come back and do a supplemental, we're going to do a supplemental for today, right now. And then we're going to, excuse me? I don't see your light on. Chairman Lumsden.
Mr. Chairman, I have 2 bills. First bill, House Bill 33, which is third item down, first one under modified structured rule. It's a bill that deals with active duty military personnel and the renewal of a weapons carry permit. Under current law, there's no provision for the renewal of a weapons carry permit after it expires. And when our Georgia residents who are members of our armed forces are deployed on active duty outside the state and his or her weapons carry permit expires, then they have to reapply, be fingerprinted, and go through the whole background check and pay additional fees. I think that sends the wrong message about their service. So House Bill 33 will simply keep the permit in force and provide for a 6-month grace period upon return to the state from active duty, and allow for renewal of the permit instead of having them to reapply. Same process we use for driver's license and professional licensures. Okay.
You have no questions.
The other bill is House Bill 279, first item on second page. This is a bill that addresses dealing with off-duty employment and sworn law enforcement officers of the Department of Revenue throughout various departments of state government. We have a number of departments that have, as part of their structure, post-certified officers in uniform who drive marked and unmarked vehicles. Many of the departments, such as the State Patrol, the GBI, and the DNR, already have language in state law that permits their officers to do this, subject to the approval of their director. This bill simply puts the language that's already in place for our major agencies, the State Patrol, GBI, and DNR. Just simply puts language in place that permits the sworn officers of the DNR to do the same thing.
What's the liability of the state if one of these officers who is providing security for some private business while they're off duty, they're driving a state car? What is the potential liability for the state under those circumstances?
Same liability that it would be for the ones that are already doing it, the State Patrol, the GBI, the DNR, same degree of liability.
But what is it?
I do not know that, sir.
Okay, we have Chairman Fleming.
Mr. Chairman, I was going to try to offer an answer to your question, if I may.
Please.
Mr. Chairman Lunsden, this is the bill that you and I discussed about allowing the officers to work, what do you call it, specials?
Correct.
Yeah. Currently, under Georgia law, we allow these officers to work what are referred to as specials. Quite often, local governments will require you to use their facility that you have a police officer there. State Patrol can do it, GBI can do it. The officers that are at the Department of Revenue could do it right now. That's not the problem. The problem is they can't drive their police vehicles there. If you have them there working a special, you want them to have their police car there so that they can respond as needed for their purpose of existing there, that is to act as a police officer. So all this does is it takes the fact that when they drive their state-owned vehicle to that location, it will be covered under state liability coverage. Does that answer your question, Mr. Chairman?
Yes, sir.
Okay, thank you.
Any other questions? I see none. Thank you. All right, now we're going to set up a supplemental calendar for today rather than have to come back later on today to set that. And then we will set the calendar for tomorrow on Thursday. So supplemental calendar, House Bill 33. It's on. House Bill 171. It's on. House Bill 341. It's on. House Resolution 239. It's on. And that's the supplemental calendar for today. Now the calendar for tomorrow. House Bill 31, which is the budget.
Move.
It's on. House Bill 64.
Move.
It's on. House Bill 68. It's on. House Bill 134. It's on. House Bill 197. It's on. House Bill 257. It's on. House Bill 277. And House Bill is on, and House Bill 321. It's on. And that's the calendar for tomorrow. We are adjourned. Carson's got to be the first person ever got his bill on and never asked for it.
That's right, yeah. Golly.
I didn't realize it till after I'd already done it.
Well, after that bill passed, it was 3 days before we went